conference. Bonus points if you've managed to join for all of those, and welcome to anyone who's joining us perhaps for the first time. For the last 3 years, we've done an interactive session to try and cover off some of the most popular compliance topics. And when you signed up for this event, you had the opportunity to vote on what topics you would like covered. And the votes are in, so we've narrowed it down to 3. And the clear winner was you wanted covered adequate and appropriate insurance. So we'll be talking about that. Secondly, you wanted to hear a bit more about managing succession. So we'll be covering that topic. And finally, reporting misconduct. Now, ideally, if we've got time, we'll get through all 3 of those topics. We've had quite a few questions in advance, but the idea is that this section is interactive. So if you click on the link below this broadcast, you can submit questions. You can do that anonymously or put your name next to it. It's always nice to know where the question's coming from, and we will try to answer as many questions as possible. I suppose one thing just to say on those questions, try and keep them fairly short and punchy rather than lots of detail about a particular situation. Now, before we get stuck in, let me introduce the speakers. Now, the SRA is strongly committed to making sure it has a diverse range of employees, but we seem to have fallen rather short in terms of that diversity extending to the first letters of people's names. So the panel today, we've got Justine, we've got Jatinder, and we've got Juliet on the panel, or the 3 Js. Now, Jatinder said to me that sounded a bit like a Motown band. I prefer Triple J, which sounds a bit like a very poor 1990s boy band that my sister would do. But anyway, this will be a serious session and there'll be no singing. So let's introduce people properly who we've got here. So first off, we've got Justine Allen, who's our ethics team manager. She manages a team of specialist solicitors and advisors who offer guidance to the profession on compliance issues. And previously, Justine worked in practice working in civil litigation. Then next up, we have Juliet Oliver, who's our general counsel. She previously was a partner at Field Fisher, worked on some high-profile cases at the General Medical Council, and she leads a team providing advice on the development of legislative and regulatory policy at the SRA. She's also responsible for strategic initiatives and matters of compliance. And then finally, we've got Jatinder Loyal, who's policy associate here. He joined the Law Society group 17 years ago. He's played a key role in firm engagement and developing the SRA's approach to outcome-focused regulation. And most recently, he's been focusing his work on the account rules and client protection arrangements. So talking of client protection arrangements, that's going to be a good place to start. But just before I do that, I'm Benedict, or perhaps I should call myself Genedict for the purpose of this session, so make sure I fit in. And I work on the comms side, so I'm not an expert on compliance. In fact, I'll be the voice of regulatory naivety, but luckily I'll be asking the questions rather than answering them. So as I said, adequate and appropriate insurance was the topic you most wanted to talk about. Jatinder's our man for that. So the format of this is we're going to have I'm going to have a bit of a chat with Jatinder through some of the questions we commonly get on this issue and some of those pre-submitted questions, and then we're going to try and feed in some of the questions from you that hopefully you'll be submitting live, and then we'll move on to the next topics. So Jatinder, we've heard that law firms, some are finding it increasingly difficult to secure professional indemnity insurance, or PII. Before perhaps we go into some of the reasons for that, shall we just remind ourselves, why do law firms need to have insurance, and where in our new standards and regulations do we set out our rules on that?
Thanks, Ben, and yeah, thanks for joining the 3 Js. I think in terms of adequate and appropriate insurance, or should we say, why do firms need to have insurance? I've always seen it as a core component to not just the part of our regulatory arrangements, but I see it as a core protection in terms of how law firms then and solicitors engage with wider society. It's that core component to providing protection should something go wrong. And we are, we're all human. Mistakes can be made. And what professional indemnity insurance, PII, does is provides an avenue for the person that suffered loss to go and seek some sort of redress through that PII process. you look across other regulated sectors, and PII is a core component to everybody's regulatory arrangements, and it's one of those, should we say, requirements that make the unregulated firms, or should we say those businesses that don't fall within the regulated space, sort of stand out, because it can inform choice as well in terms of where you go to, to instruct somebody, whether it be a lawyer or another business. So I find it's like I said, a core component to how we function as a regulator, but also in terms of those that we regulate, it's a core component to how they provide that sort of security to people that they engage with. And your next question, in terms of where it sits in our standards and regulations, we often get asked this question because I think sometimes people, they start at the beginning of what our standards regs might look like on in printed format and say that I can't see anywhere where it says that I need to have insurance. This is clearly set out, the requirements clearly set out in our SRA indemnity insurance rules, sets out that all authorised firms need to have a policy of qualifying insurance. It couldn't be more simpler than that. And this goes, go to the work that Juliet and the team always do in terms of making sure that our standards and regs are simple and easy to follow. So this is probably one of the easiest requirements to understand, which is that, you need to have a policy of qualifying insurance.
And you say a policy of qualifying insurance, and this is me being the naive point of view. So what do you mean? What do we mean by a policy of qualifying insurance?
So what we've done, Ben, is as a regulator, we've set out that there's some minimum terms and conditions that need to be in place. So someone could just go and buy an insurance policy off the shelf, but we want to set, as the regulator, some minimum terms and conditions, and a policy that includes all of those minimum terms and conditions is a policy of qualifying insurance. So it sets out the minimum level of cover that's needed by firms. So depending again on structure, whether you're a sole practitioner or you're an incorporated firm, it might be £2 or £3 million worth of cover. And then other arrangements around things like runoff and succession, all of those arrangements are part of our minimum terms and conditions. But I think the point here that I'd like to make, Ben, is that, to help with your naivety and those that are listening, is that these are just the minimum terms and conditions. They're not the maximum terms and conditions. So what law firms are going to be doing in terms of assessing if they need anything more will be for them to decide.
Thank you, Jatinder. And I'm sure when you were talking about naivety, it was definitely my naivety rather than our audience's.
Yes, no, definitely. Yeah.
So let's just pick up on that. So we've talked about, you hear a lot about adequate and appropriate PII. So is that a job for firms to make an assessment themselves of what's adequate and appropriate? How does that work?
Definitely, Ben. This is, again, going back to the point that I was making, that some firms or that people out there that are looking to come into the regulated space see our minimum terms and conditions as that, we've got a policy that meets those terms and conditions and that's fine. We've issued some really detailed guidance around what adequate and appropriate insurance is, and when you look at that, it sets out some really key components in what we expect firms to be doing when making that assessment. So they have a requirement to have insurance, but they also have the requirement on them to make sure that the policy that they've got in place is adequate and appropriate. And that needs to reflect, the work that they're doing, the sort of clients that they're entertaining, the other parties that they might also engage with during the course of a transaction. If I was involved in, should we say, a conveyancing transaction, and I knew that the value of the property was, in, the 10, 15 million pounds worth, or that region, the 2 million or 3 million pounds worth of insurance that I've got wouldn't cover that should something go wrong. And this is why firms really need to look at, what's suitable for them, what's adequate for them and appropriate for them and their clients, which is more important here. It's about looking at who they're actually serving.
And just to pick up, actually, we've had one question come in here, because PII can apply in other settings, and somebody's asked, how should freelance solicitors doing reserved work assess the level of adequate and appropriate insurance? Obviously, that's quite different to a firm. How does that work?
Well, the guidance that we've issued is, it's not just limited to law firms. It's there for those freelancers as well that are doing reserve work. And that's where we have imposed the requirement for those solicitors that are working as freelancers doing reserve work, that they also need to have a policy of insurance that is adequate and appropriate. And again, they need to make that, that solicitor needs to make that assessment depending on the sort of work that they're involved in. The client that they're working with, and again, the value of the transaction. These are sort of key components, and this is what the insurers are looking for as well when they're looking for somebody to come to them with a proposal to have some sort of cover in place. They will say, okay, can you tell us what sort of work are you involved in? Are you doing commercial transactions? Are you involved in family work, or are you involved in litigation? They'll also ask questions around, your previous claims history as well. So this is really important for not just authorised firms, but also for those solicitors that are moving into the freelance space. They need to think about, do they bring any liability from wherever they've worked before as well, which is really important in making that assessment. And I think, Juliet's helped us, with the guidance as well. I'm not sure, Juliet, whether you want to say anything about guidance there, just in terms of how it should be used, because I think we've got case studies as well.
Yes, I think that's a really good point. I mean, the guidance is helpful in highlighting those sort of factors to think through, and it does have some case studies as well. And I just wanted to make the point really that reinforcing what you said earlier, Jatinder, about this assessment will be really important for firms and freelance solicitors and those who need insurance to work through to make that assessment. It really is a core protection. So what you'll be doing, obviously, is looking at what you need in order to protect yourself and ensure you're financially sustainable and clients are covered. So that's obviously going to be very important. From a regulatory point of view, we're not going to second guess that assessment. We're not going to be looking at double checking your cover and its terms on any kind of a routine basis. What we want to know is that you have made that assessment carefully, and that you've looked at the kind of factors that we've set out into the guidance. So it's really just about making sure, from our point of view, that you can demonstrate that you have carried that out, and you've as I say, considered those kind of factors when you're making that judgment.
And that, Juliet, is very much in the spirit of the standards and regulations in general, isn't it? That we're not trying to second guess judgments, but you should be able to show your working if it comes up in an instance that you've made a judgment and you've shown that you've thought about what the rules are, and you've made a sort of a defensible judgment. Would that be right?
That's absolutely right. I mean, you're going to be in the best position to know how your firm works, what kind of clients you have, what kind of issues and risks you've got. What we'll want to know is that you have thought about that carefully. So, as you say, Ben, keeping a note, something to show your workings is always going to be helpful in case there's ever a question.
And I think it goes back to, Ben, the point that we were making, that insurers, as part of the the process of getting insurance, they've got their proposal forms that firms or individuals have to complete. So a lot of information will have to go in there, and I think it's really important that firms are really I'd say honest with a small h, in the sense that they really need to be sure about what information they're giving and can back it up as well, going back to Juliet's point, that that they can back it up with the information they've got from other people within the firm as well. And another thing that links to this is that the code sets out very clearly, so the code for solicitors sets out very clearly that you have to confirm to your clients the regulatory protections that apply when you're engaging with them. So this is one of those core components that we were talking about in terms of having a well-functioning regulated community.
And so, picking up on that, you've talked about the risks of, I suppose, not having PII, and obviously there's a big risk overall to the reputation of the profession and public trust, because that's something, those type of protections are one of the big sales points of using a regulated law firm. But I suppose anything else to add on the risks, Jatinder, if a law firm doesn't have PII?
Yeah, this is really that where we see the sort of circumstances where firms have either just not sorted themselves out, or they've got into where we're seeing now the hardening market, where it is becoming quite hard for firms to get insurance. And yes, if firms haven't got insurance, then, and if there is an act or omission which gives rise to a claim, then the client or the third party that suffered loss is just not protected. And so it's really, really important that firms do have insurance and as a minimum has a policy that complies with, like I said, our minimum terms and conditions. And in terms of the risks, then that we have to make sure that consumers are still protected, and that's where the compensation fund rules do kick in. They provide a safety net for those that have suffered loss where a firm should have had insurance. So this is authorised firms that should have had insurance in accordance with our rules but didn't.
And that's great, Jatinder. And we've just had a couple of questions coming on this, and let me just run those past you. And Justine, it might be something you want to chip in on. So the first question is, if I'm acting in conveyancing purchase with a consideration above my PII, can I limit my liability with my client? Thanks for Leonard for that question.
So this is set out in the indemnity rules as well, that no one can limit their liability below what we've specified. So anything outside the minimum terms and conditions is up to the client. It's a case-by-case assessment, and goes back to the points that we were making as well about letting the clients know what sort of regulatory protections apply. And if the client's not happy with a law firm or an individual solicitor limiting their liability, and just limiting it just to £2-3 million, that the client might think, I need to actually go somewhere else. So it's a good question, but in terms of how practical and the sort of what the impact it has on the relationship with your clients is something that firms and individuals really need to think about.
But clients may be prepared to take that risk, and you do need to have that discussion, because that might be something that for them, what you're going to be providing for them, the cover that you can provide, that ends up being advantageous, and they may be prepared to do that. So I think it's it is a really good question, and on a case by case, client by client basis, you might find that is something that is possible for you.
And that might be possible. Would that be more likely, Juliet, if, for instance, a client had been using a solicitor for a long time for certain types of work, and then wanted to carry on using that solicitor?
Yeah, absolutely. If they know that you're going to be the best person for the job for various reasons, or they have other arrangements, they have other sources of backup funds or insurance or the like. This may actually be something that depending on the nature of the client, if they're a big a sort of larger big business client, there may be good reasons why this is something that they're prepared to accept in the context of all of the terms of the retainer, really. So that is once again something that you'll absolutely be best placed to know and to work through. And I think the point that Jatinder made before about the transparency around your arrangements with the client, making sure they really understand the protections that being regulated brings, and the minimum terms, but then of course how the whole matter is going to be arranged and handled is going to be key there.
And Jatinder, you mentioned the hardening of the PII market. I mean, this is an interesting one, isn't it? And I know you're out there talking to firms and insurers all the time. I suppose, is the market hardening, and what's behind that?
There's lots of reasons, Ben, and this could become a session in itself. And the other regulator.
Justine and Juliet, you can stand down, and we'll move on to that. No, we'll stick to that. Sorry for interrupting, Jatinder. Go on.
No, the insurers are regulated either through the Prudential Regulation Authority, the FCA, and then there's Lloyd's of London as well. And all three have had sort of input in terms of how professional lines of insurance have been written over the years. And another thing that impacts on, the hardening market is the claims history over the years as well. That over the years we've seen sort of peaks and troughs, or just sort of even just continued peaks of claims coming through for different reasons. And because of that, insurers have now really had to look hard at what they're actually covering in terms of risk, because it's getting harder for them. They're regulated as businesses as well, so their regulators are asking them questions. But also it's that the risks are changing. In terms of what insurers are covering, that law firms are becoming involved in different ways of working, and with that brings risk as well. But the hardening market, I think it's become I'd call it, it's the funneling effect, but the other way around, that all of a sudden it sort of started off fairly narrow and has now sort of just pushed out upwards, and people are seeing the impacts. And it's not just one type of firm in terms of size or the work that they're involved in. This year we've actually seen it's across the sector that, different types of firms for different reasons are just finding it hard to get insurance.
And we've had another question come in, and this question is, how effective is a limitation of liability clause in the firm's T&Cs to limit liability to the amount of PII? And I think there's a few questions on that limiting liability point. Any thoughts on that?
I think Juliet covered it, sort of in terms of how effective it is depends on what you've actually discussed with your client. Putting something like that into terms and conditions goes back to that transparency point, that if the client doesn't know where it sits in the T's and C's, then they're not going to be able to make an informed decision or even consider whether or not other arrangements need to be put in place. So in terms of where you put it, especially when the fact that we've moved away from having written client care letters now, and the fact that it's about how transparent you are as a firm and individual in giving your client the assurances that they need, but also enough information to make an informed decision. It's one of those, firms really need to make their own assessment, and if they know that the clients are going to read the terms and conditions as well.
Okay, that's great. Juliet, did you want to add anything on that?
Well, it wasn't on that point actually, but I was just going to come back on a point that Jatinder made earlier, which I thought was just perhaps worth sort of emphasising, really, which was this point about the compensation fund, because of course, the compensation fund does give us a discretion to make payments where individuals have suffered loss because solicitors or firms haven't got the cover that we require them to have. But I just thought it was worth making sure that really we sort of covered the point that the compensation fund, of course, has a different role, has different statutory purpose. It's operated in a different way. It is a discretionary fund, and it's not really. What it's not there to do is to fill in or top up gaps in cover. If you've got cover, but for some reason, your cover is, your insurance is voided or it doesn't cover a particular issue, the compensation fund, can't back that up. It really is there to help individuals where solicitors firms have fundamentally failed to do what they're supposed to do. So it's where they should have had a policy in place, and that policy would have covered the issue. Then there's a discretion to make the grant. And I did think it was worth just picking that up, because I think that actually that change has been in place that clarity has been in place for a while in our rules, but certainly historically there has been some confusion about that. But I just wanted to make that point clear, really.
Thank you, Juliet. We're going to try and cover off a couple more questions before we move on to our next topic. Thank you for everyone who sent questions in. This is another one that's just come in, and this asks, for firms which are companies, should they have D&O insurance, which I think stands for Director and Officer Liability Insurance, in addition to PII?
Yeah, Ben, that again depends on again, the arrangements that the firm has with its, directors. The minimum terms and conditions has got something, as part of them, we have exclusions. So it does cover, it excludes liability for directors and officers. So that's it. That's written in the minimum terms. But in terms of whether or not a firm should have that extra layer of insurance, then that's for them to make that assessment depending on the nature of work that they're involved in. But also the agreements that sit behind each person's appointment, because there's going to be people that are worried about personal liability. And I think case law has sort of now made this area even more grayer than it was, because there are circumstances when directors could be personally liable. So it has to be, again, part of the firm's assessment. It's not something that we prescribe as part of our rules. Our focus is on, consumer protection, not protection for role holders per se. So this is something that, individuals have to think about as part of their makeup in the firm.
Yeah, that's great, Jatinder. And I suppose I wanted to, in terms of a more sort of, positive question, what could law firms do? Do you have any tips to help themselves so they're not seen as high risk to insurers? What steps could they take?
I think first thing is just to sort of, do that self-reflection. A lot of firms sort of, it's very much a sort of forward looking that this is what we're going to be doing in the next year, 2 years, 5 years. I think it's time just to look backwards as well and just say, okay, how have we operated as a firm? Have we had the sort of Trustpilot reviews where we've got 5 stars, or are we a firm that's unfortunately got a history of claims or complaints to the ombudsman? And thinking about how firms need to do that sort of change in whether it's culture in terms of how they work, looking at their systems and controls, all of that. And I think, again, going back to our standards and regulations, I think last year was the perfect time for firms to sort of do that, health check, self-assessment, and say, okay, where do we need to be? Because the flexibility that the new regs bring is, you're not bound by prescriptive rules. So develop a system and a framework that suits you. Another thing is always be open with your insurer. Use your brokers if you have to, but insurers, a lot of insurers accept direct, the direct approach as well. So it's always key about being open with your insurers, because what insurers don't like is surprises, because that then leaves a bad taste in their mouth, and then they're less likely to provide cover the year after as well. And if firms do struggle to get insurance, they need to talk to us. That they need to engage with us, Ben, because there's so many issues then that come about. As Juliet mentioned, that potentially the compensation fund comes into play, but the biggest issue that we have to then deal with is that if the firm can't get insurance, then we need to make sure that firm's closing down in an orderly way.
Which I suppose brings me on to my final question, and probably is a fairly good segue to managing succession in terms of orderly closures. So if a firm is unable to secure PI cover, or they know in advance of their PI renewal date that they're better off ceasing, you've said they should get in touch with us. Is it what else should they be thinking about, or is it just pick up the phone to us and we'll give them advice?
Well, the rules set out the notification requirement. So, that if a firm has entered, gone past their renewal date and hasn't secured insurance, they fall into the extended policy period, and they have to let us know. And our teams then will engage with them to try and find out what they're doing to sort themselves out. If they haven't sorted themselves out in that first period, they move into the cessation period, which is then that they really need to be thinking about what they're going to do next. In terms of the firm structure, but they can't take on any new instructions either. So it is moving them into sort of the space of, limit your liability in terms of not picking up any new work, but also you need to be very engaged in terms of what your future, sort of prospects are in terms of carrying on, but also looking for things like, a potential merger or acquisition opportunity. If not, then it is thinking about an orderly closure.
So should we move on then to succession? Thank you everyone for those questions on that topic. We're now going to move on to succession planning. So please send your questions on about that. Also, if you've got questions about reporting misconduct, please send those in as well. So if I move over to you, Justine, why does planning for succession matter?
Well, I think that the clue is in the question, planning, because you need time and you need to give it a lot of thought to be able to plan to properly close down. And if you do that and you do it right, it can benefit you, it can benefit your clients, your staff, businesses that you might deal with, and potentially your family members. But the main reason is because it takes time and you'll get the best outcome if you do it. And it also matters to the SRA, I think, because obviously here in our role as regulator, we've got an obligation to protect the public. And we also, as one of our key objectives, are keen to help small firms and sole practitioners who may struggle or for various reasons may be more at risk of having to close their firms suddenly and may not have the time for planning.
And I suppose, hands up here, we know how busy solicitors and law firms are. And we also know in terms of planning for succession, it's something you can always put off to the next day. I'm guilty of that. I think, hands up, I don't have a will as of yet. Some people might see a business opportunity there, but that's always something I know I definitely need, but I haven't got round to doing. So it's a perfectly understandable thing why you might not get round to it. But should we just remind ourselves, Jatinda mentioned that PII might be one reason why you have to close down because you're struggling to get that. But could you just remind us what are the types of other reasons firms might need to close down?
Yeah, absolutely. Well, there could be lots of reasons. You might want to retire. There might be a change.
Hopefully we all do someday.
One day, yes, yeah. Absolutely. There might be a change in your personal circumstances. You may suffer from ill health, for example,
or you might want to just go and do something different. You might not be retiring, you might be going on to pastures new, or it might be external events. And COVID is a good example of when something externally happens that you couldn't have foreseen, and where you might want to cease practice. And obviously, you've got an obligation under your professional rules to consider any risks to your business, maybe the ones that you can foresee as well as the ones that you can't. And this should include how to close down the firm in the event that that's the only or the preferred option.
And so we talk about closing in an orderly way. How do you do that? What's our advice there?
Okay, well, I suppose the starting point is to assess the steps that need to be taken and any risks arising from actually closing down. So where to start? Well, as my colleagues have said previously, keeping a record of what needs to be done is very important. That's not really just necessarily for you to follow, but it could be for other people to follow. So if, for example, you were suddenly incapacitated, or heaven forbid you died, it would be really helpful. And we have situations like this on our helpline where we have the office manager phoning us, or perhaps the spouse of the solicitor saying, I don't know where to start. That sort of plan or checklist, if you like, of what needs to be done is invaluable to them. So I really strongly urge people to think about that and to record what needs to be done. So thinking about what steps there are that need to be taken, well, it's things that we've touched on already. Jatinder referred to the need to think about what client matters you've got at the moment. Do those files, are they nearly completion, or are the ones that would need to go to other firms? And then we come on to file storage. Would you need to look at putting the files that you've got into storage? Do you have a plan for the safe and secure storage of documents with a destruction policy attached to it? Because we've found, and we've spoken to practitioners who are being charged large amounts for storage of physical files. So that can be a big impact on firms when they're closing, and an expense that perhaps they hadn't foreseen. And getting onto the financial side of it, if you're going to have to go into run off and to close because you don't have a successor practice, you may well need time to save funds to pay for that run off cover, because that can be very expensive.
Jatinder, did you want to come in on anything on that run off cover point?
I think it's, Justine's covered it off, and I think, well, in the sense that, you need to be saving for this because it can be quite expensive, and it always reflects the firm's risk profile as well. So, it's only going to be expensive if, you've got a poor claims history, or, your risk profile is such that the insurers are worried. It's something that some firms really forget about, that, that the core component of having a good firm is also thinking about, when you close, that your clients still need to be protected because something could come out of the woodworks, which is what runoff does. It provides that 6 years cover that we mandate, and something that firms really need to think about. And I think this is where the insurers are getting really quite concerned around that firms are just not telling them that they're looking to close, or they have closed. And the first time that they realise that the firm has closed is because either we've intervened into the firm, or that there's a claim that comes through. So it's really important. It's a core component, and something that we've done for small firms as part of the starter pack is included a comment around, or a section around, thinking about succession from day one. And that includes saving for things like the rainy day, which will include run-off cover. And I think it's really important because if firms are struggling, and I think, Juliet, we've done some guidance, haven't we, around firms that are in financial difficulties. And I think Justine mentioned it as well, that this year, the external factors have sort of changed how we work.
Yeah, that's right. I think, it's really a very pertinent time for us to be, trying to put out some information to really make it clear, what firms should be thinking about where they might face difficulties. Put the points that Justine has run through, some of the issues that they need to have on their checklist. And I think bearing in mind particularly the difficulties this year, as Justine said, health difficulties, financial uncertainty, and financial stability problems are all things that the pandemic has really brought to the fore. So we did put out some guidance which has helped to have that reminder of the things people need to think about. But also, I think really importantly, it made the point that, as Jatinder mentioned, ultimately what our concern is going to be that clients' money is protected, and the risks of firms running into the buffer and there being real problems, and of course ultimately we may have to intervene. But we don't want firms to be fearful that's the inevitable outcome of any problems that they might be facing. That is very much last resort where really nothing else can be done. And actually, it's that point you were making about speak to the insurers, talk things through, be open, think about these things in advance. But actually, if you find yourself in difficulties, speak to us, because we can help trying to support you through that process, hopefully help you to get on track or resolve the problems that you have, but if not, actually really help to manage that orderly and effective wind down process, which means that that doesn't have to happen. And I think it's we really want to encourage people not to feel that either we're going to overreact or rush to intervene, or that's going to be inevitable. Actually, we can really try and help to work through things.
That's helpful. And I suppose the one thing that often I think people think about planning for succession is where those who are most at risk, the perhaps sole practitioners or very small firms where there isn't the resilience there. But this is actually an issue as well for larger firms. What should they be thinking about in terms of planning succession? Justine, perhaps if you'd like to answer that one, is it?
Okay, yeah, absolutely. Well, indeed, large firms do need to think and plan about a plan for succession. So, for example, what if the managing partner or one of your key role holders was suddenly unable to work, or they left the firm? So developing your staff takes time. Finding someone who's the right fit for your particular firm is very important and should form part of your long-term plans for the future of the firm. And Jatinder talked about planning for the future of the firm in terms of the areas of work perhaps that you do. It's something that's vitally important for all firms, but for large firms that's probably particularly pertinent. You might want to change an area of law that you're doing, and that might have be as a result of something external, an external factor such as COVID, which has led to a change in the market. Firms need to be agile nowadays and to respond to changes in order to survive as a viable and profitable business. So it's planning, but it's also being flexible to be able to address those sorts of things.
And that's interesting. I suppose if you're considering a sort of a merger or takeover, I know there's some quite sort of complex rules around that. But yeah, that's something. How far out should you be thinking about or planning for that, or can you in terms of succession?
Well, I suppose in terms of mergers or acquisitions, it's not something that you can go and talk to other firms about until you're ready. But at the time that you are, you'd need to obviously check out the people that are interested in purchasing your firm. Are they SRA regulated, or are they regulated by another regulator? That might have an impact on your clients. The timing of it. So it may not be particularly a good time for the sort of work that you're dealing with, or the sorts of matters that you're dealing with. You'd have to address lots of things, and we've talked about the time factor already. But for example, you've got to look for conflicts of interest that might mean that you'd have to cease acting after a merger. The other issue is whether the new firm is going to become a successor practice or not, and that can have a big impact on the firm. It is a possible way of closing, but your firm might not be as attractive as you think it is, so you shouldn't rely on some sort of merger or takeover automatically as a way of closing down. It's a possibility to explore, but don't rely on it.
like many things in life, some things aren't as attractive as they think they are, or people who think they are. But perhaps we've got about 20 minutes left, and I'd like to make sure we get on to our last topic. So I suppose the final thing I'd just say, Justine, just a reminder of what would be your final sort of key tip or takeaway for someone who's thinking about planning for succession.
Okay, well, consider the risks to your business and to your clients, and put your plans in place early. It's never too early to start planning and saving, probably.
Well, thank you, Justine. And so now we're going to move on to we're just on time, I think, to cover off our last topic, which was around reporting concerns. And Julia, I'm going to come to you on this one. We've had some questions already in about this. We've set out in guidance, I think, for a year or so now, what our expectations are in this place. But perhaps it'd be worth reminding everyone, how do solicitors and firms know what they should and should not be reporting to us?
Yeah, absolutely. So, as you say, we did recently clarify our rules and our guidance on this area. So for those who were here a couple of years ago, as Ben said, we covered the topic at this session at Compliance Conference a couple of years ago. You'll have heard that we consulted widely on the changes in this area. They came in, the new rules came in from last November, a year ago. So that was along with the rest of our standards and regulations. So I would say there's probably 3 key points just I wanted to flag, really, to note about it. The first is that, the changes make the rules around reporting consistent. We use the same language and the same test for both self-reporting and for reporting others, and it's the same language and the same test for individuals, for firms, and for compliance officers as well. So the rules are found in the relevant parts of the codes of conduct. So that's paragraph 7 of the individual code, paragraph 3 of the firm code, and the compliance officer stuff is in paragraph 9. So that's the first point I'd make. The second is, yes, absolutely, Ben. It really clarifies the test and what people should be thinking about, what this really means, and it clarifies that this is about reporting facts or matters when you reasonably believe that they're capable of amounting to a serious breach of our rules or requirements. So what that means is you don't need to be sure yourself that there has been misconduct, or to itemize the allegations for us, or to have concluded an investigation until you're absolutely sure. That is our job. What you need to do is refer to us matters that have come to your attention that are serious enough and are capable of proof. And so the third point I'd say, which I think that last point really underlines, is that it encourages reporting at an early stage. That allows us to use our powers to investigate, to compel production of documents, to interview witnesses. Often that will be allowing us to go to places and find out information that you wouldn't have been able to do in an internal investigation anyway, because we'll be going perhaps to other firms or to client departments or wherever we need to go. And of course, in the most serious cases, we might need to take interim action. So we might need to, for example, put conditions on the practicing certificate or authorization to protect the public, or even in the most serious cases, consider intervention. So of course, knowing about things early helps us to really piece together the picture and work out what we might need to do as a regulator.
And I think that is the case. There are cases, aren't there, where we've been able to join the dots of several different reports or several bits of information to actually see a pattern of behaviour that's something on the surface that might not look at the ultra serious, actually it might actually turn out to be the case, which is
that's right. And if we get it early, and you might sort of say, well, we haven't fully investigated this, that you might worry that might mean that we're not interested. But no, actually we might be in flight in an investigation of some linked or other issues, which can we can add that to our investigation. It can help us to get a rounded picture of whether there are real problems or risks presented by whoever or whatever.
And building on that, we've had a question come in from David, and it's around that sort of issue of reporting. And does it mean that anything and everything should be reported to us? Is there a danger you almost, for want of a better term, get defensive reports from firms?
Yes, and that I would just say that isn't what we want to encourage, and defensive reporting. I mean, I think no, that's not in anyone's interest. I mean, it's for one, it's not in your interest to feel like you have to act as a postbox and you're just passing matters through to us without kind of giving them your thought as to whether they really present risks or an issue. It's not in our interest for us to receive volumes of reports on matters which would or could never lead to our taking any kind of regulatory action. So, we do want you to exercise your judgment, to decide whether the issues engage our rules, decide whether they're serious enough. And while I've said you don't have to have gathered all the evidence and concluded matters and found all the facts proved, the requirement for a reasonable belief that the matter could be one for us, I think that indicates it goes beyond kind of gossip or suspicion. So you don't need to be just passing on any suspicions or any or anything without really giving it that thought yourself.
And I know one of the concerns, or one issue that was raised when we were consulting on this as a topic, Juliet, was concerns around almost whistleblowers, or people, if somebody blows the whistle on something, whether they're sort of have action taken against them. What would you say to people if they're worried about repercussions from other people they work with, for instance, if they're reporting a solicitor or partner or somebody in their firm?
Yeah, I think, this is, I really understand the issue and the really sensitive and difficult position that people can find themselves in. And I think, as you said, that came across really strongly in feedback during the consultation, how concerned people are about this. And I totally recognise and understand that. I think there's a few things that I would say really in response to that. The first is, perhaps first and foremost, when we're looking at taking action for a failure to report, we do, as with all breaches, look at the context, try to understand people's behaviours and motivations. Part of that is the environment they're working in, the pressures they're under. And that really is something we'll take into account when we're deciding, whether to investigate that as an issue, or if we do, whether we think any action is necessary. Because as we've said in our guidance and in our enforcement strategy, what we're really trying to do is differentiate between people who are essentially trying to do the right thing and those who aren't. And we're not interested in trying to penalise people who are genuinely at risk or in crisis. And if you're in, you feel you're in a difficult position, we will understand that. So that is something that, hopefully provides some comfort to people. But there's a couple of other things I think might be useful just to emphasise, really, because that said, people do have a duty to bring risks to the public interest to our attention. We need people to feel able to do that without fear of repercussion, and that's something that we take very seriously. So just to reassure people, for one, we have got significant experience of dealing sensitively with the issues that are brought to us, and with dealing with requests for confidentiality or anonymity. And we have got some guidance out there on reporting to us, and that sets out about a little bit more information about how we approach that. Some of the issues, something that's tricky, some of the tricky sort of areas around that in terms of what we can then act on or how we would approach it. But that's all set out in the guidance, and I would recommend that people might want to look through that or give us a call and talk through issues with us, and we will totally respect requests to consider perhaps things anonymously, or things where they might want to do it on a no-names basis, just to talk through the issues and the scenarios. The other thing I wanted to say is, responding to the consultation feedback, we have included in our rules a really clear message confirming that we're not going to tolerate attempts to prevent others from providing information to us, or where somebody subjects anyone to detrimental treatment for making a report to us or indicating that they propose to do so. So, we will enforce that if we see that happening. And finally, I just make the point, which is that we really know that you people on this call, many of you will be compliance officers, and we all know you'll be keen to provide support to people and make them feel able to come forward and talk to you. And we want to support that line of communication. And we've said in our rules that the obligation to report to us will be satisfied by people reporting to you. We know you and your systems can help to kind of encourage that open culture.
Yes, because someone who's never reported to the SRA and maybe fairly junior within an organisation may feel far more comfortable going to their compliance officer than maybe straight to the SRA. We've had an interesting question in here, which is somebody asking whether we would consider a firm consistently threatening to report another firm, I presume, as part of a negotiation tactic as reportable behaviour of itself. I mean, sort of suggesting almost an arms war in terms of reporting. But what's our view on that on the surface of it?
Yes, I mean certainly that kind of perhaps oppressive tactic. It isn't something that it's something that we would consider to be concerning, put it that way. And we have seen examples of that where either oppressive sort of threats of litigation, but oppressive threats of reporting is something that people can use to essentially try to strong arm their way in a case or a matter or an engagement, and absolutely that's something that in serious cases we have seen reports of that kind, and we've taken forward investigations into that kind of behaviour.
And I suppose linked to that, when we're talking about reporting concerns, as you said at the start, is we're not just talking about individual conduct issues. We are talking about firm issues. And what type of issues should a firm be reporting?
That's absolutely right. We talk about the requirement to report being breaches of our regulatory arrangements. So that includes, the obligations that a firm might be under our firm code or the accounts rules. If there are breaches of those. So perhaps where there are accounting failures, perhaps patterns of breaches of the accounts rules, resulting in delays in clients receiving funds or failures getting their money, failures in systems or controls, or the actions of employees leading to a firm breaching the conflict rules or breaches of confidentiality, supervision failures which might kind of lead to patterns of poor outcomes for clients, failures to meet court deadlines or requirements. So anything really that that if a firm is breaching the requirements placed on them, that is something that could be reported to us as well. And actually, it might be worth just saying, quite apart from the reporting misconduct side of things, there are of course other requirements for firms to notify us of matters so we can understand the issues and risks they're facing. So we do talk about, and perhaps pertinent at the moment while we're in lockdown, firms reporting to us cyber attacks, so we can understand and build a picture of what's happening out in that area and the risks to the sector, as well as trying to help to understand if you're vulnerable to attack, or if you have suffered one, how best you can help to protect yourself.
And picking up on that pattern of behaviour point, I think that's probably linked to the next question we've had come in. So thank you for the person who submitted this. They've asked, should I report if another side in a case is clearly not reporting a SAR, I presume it's a suspicious activity report concerning their clients?
Yes, I think this is certainly something that as ever, what we look at if we think a firm hasn't done what they should have done is, is this serious? And when we're talking about serious, we're looking at what's their motivation. Are they trying to conceal something? Is there an honesty issue there, or have they been reckless as to their obligations? And that would make a failure really quite, those are some of the factors that make something more serious for us. Or if in and of itself it might not seem serious, is there a pattern here which suggests that there are poor practices across the board, or poor systems or controls in place to make sure these matters are picked up? And so those are the kinds of things that might make not reporting a SAR something that we absolutely would be interested in. Yeah.
And Jatinder, perhaps I could bring you in just on a question. A common theme we often hear about is this idea that, solicitors obviously need to be transparent in their dealings, but whether that's with insurers or, law firms seeking to buy them out, we obviously expect solicitors and law firms to cooperate with us at all times. Should firms be reporting concerns to us if they feel another firm hasn't been transparent?
Yeah, I would agree, Ben, because what it is, it's that there needs to be, transparency. I always say brings trust. Something that I've really picked up, doing some of the work over the last couple of weeks, that that where there's transparency, there is an element of trust, and both sides of a transaction need to have that trust so they can, provide a really good service. And I think it does go back, because what this brings is that that if something potentially is going wrong or something's not being followed up, it could result in a claim on the indemnity side of things, so that it could result in a claim on the firm's indemnity insurance, either side, because something hasn't been followed up. So if I'm a client on this side and I know that the other side should have done something, then I as a client might suffer loss. But the same on the other side as well, that somebody should have done something. So it's really important that firms really engage with us. Goes back to Juliet's point that that if you are worried and there's things that are going on, let us make that decision as to whether or not we need to engage with that firm, and if it then does require any sort of us to engage our enforcement strategy. But the important point here is that that it's being open and transparent, building that trust in the relationship, because other people will then become very worried in the sense that it could, especially if it results in a claim on the firm's indemnity insurance.
And Justine, perhaps I could bring you in on the next question we've had. Someone's asked, should they report a solicitor for using racist or sexist language, or an approach when dealing with us?
Well, yes, I think we probably ideally like to discuss the circumstances. So I'd encourage them to phone the ethics line and we'll talk through with them how that's arisen. But if there's clear breaches of the law, such as would be the case if it was racist or some sort of breach of the Discrimination Act, then in whatever format that's taken, then that has led in the past certainly to SDT decisions and to disciplinary measures, and sanctions are being applied to solicitors. So yes.
And on top of that, don't you have the issue of trust in the profession? Is that, Juliet? Is that what you?
That was exactly.
Yeah.
You took the words out of my mouth.
I know something. I have one victory.
You're not so naive after all. No, I mean that's absolutely what I was going to say, which is that we do see issues like this, and we have prosecuted before the SDT issues around offensive communications, emails, exchanges. Not only do solicitors and firms have the obligation on our code not to unfairly discriminate in the way that they, in their dealings and in how they conduct their business, there is also the principle which gives an obligation to promote equality, diversity and inclusion, and the principle to act with integrity. And these are some of the issues that we've seen and we've prosecuted before. So that kind of a language is something that, going back to what I said, this hook I keep on sort of hanging things on is something serious, is something a serious breach. Discrimination, any kind of racist or sexist sort of connotation to what's happened is absolutely an aggravating factor that makes something very serious in our eyes.
And isn't it the case, Juliet, in thinking of the most serious cases that have ended at the ST Solicitors Disciplinary Tribunal, if I can get the phrasing out right, that often, if you look at our enforcement strategy, if there's a pattern of behaviour there, that's very different if there's to perhaps something where somebody's said something but immediately apologised, held up their hands are wrong. Those might be mitigating circumstances, although obviously we would judge each case on a case-by-case basis. Yeah, we absolutely would judge each case on a case-by-case basis. But I think that we can extrapolate some kind of common themes or factors which might tip things, either aggravating factors or mitigating factors. And actually, on offensive communications, we do have a topic guide which sets out some of those aggravating and mitigating factors. So what might mitigate and lead us to either taking lesser action or deciding that we're not troubled at all is if something's very out of character, if so it shows that there was an act out of character that is immediately apologized for, the post or the communication is removed, showing insight or showing that this was not something that actually really reflected the person's demonstrated a lack of integrity actually. Conversely,
aggravating factors, and I think discriminatory language certainly is one of them, or if there's a pattern, or if there's a failure to remove something despite warnings, or despite knowing that it's causing great offence, and things like that would certainly be more, would aggravate the matter.
That's really useful, and I know I'd encourage people to read that guidance that note, because I think it is very helpful. I note we've just come up to 3:30, which is our finishing time, so I wanted to say a huge thank you for everyone who submitted questions, and a huge thank you to the 3Js for all their answers. I thought that was a really useful session, but it doesn't matter whether I found it useful, it's more whether you found it useful. So we do have a link to evaluation below. We'd really appreciate if you could click on that link. It will take 1 minute. Let us know how you found it and how we can improve it. Also, I know we had a few questions come in, sorry, we haven't got to, and a few topics came in that we haven't got to, so we can consider those for perhaps next year in terms of if you'd like them covered. So we'd like to hear about that. I also understand we've had a few pitches for work to write my will, so thank you for that. And perhaps one of next year's sessions should be on unsolicited approaches or touting, and whether me shouting out there that I need a will, whether that counts or not. I can become my own case study. I am being slightly facetious, of course. But I wanted to just say thank you. We do have another 2 days left of the compliance conference. Next up, we have what should be an interesting session with our chair and chief executive at 11:30 tomorrow, and that's with the journalist Daisy McAndrew, and she's going to be talking about some of the big picture issues currently in the legal sector, what their thinking is about that, and where they think things are heading. So tune in for that, and then we've got cybercrime, I think, in the afternoon. But otherwise, thank you everyone for watching. Thank you again to our panelists, and I hope everyone has a good afternoon.
Thanks, Ben.
Thank you.